question.
What was the question again? I'm sorry. I'm just mad because I feel like I'm in here for no reason. I'm sorry. But
when's the last time? I'm sorry, sir. Go ahead.
What was your question, ma'am? I'm sorry.
All right, the board call for number WR23-00084, Jonathan Lee Lyons versus the state of Texas. All right, Mr. Lowe, do you want to call your client to testify at all today?
Well, so, Your Honor, real briefly, he's been incarcerated now for about 60 days. And so we've got this misdemeanor class A. So I think he probably would be entitled to a PR bond on that one. I've told the court in the last hearing, and I've told the district attorney, this hearing is about bond reduction. And so I advised the court, I got a copy of the offense report there's 4 offenses. So I'm not arguing about probable cause. I just think the bonds in these cases are absolutely ridiculous, or what the charges and what the offense report says. So I think he's entitled to the PR on them. So I guess we need to dispose of that first, Your Honor. See if he's.
Okay, so I guess I'm a little confused. So you're asking me to grant a PR on a Class A misdemeanor. I don't even show a Class A misdemeanor before me. What I show is a delivery of controlled substance or marijuana to a child, harboring a runaway child, possession of controlled substance penalty group 2 less than 1 gram, and possession of controlled substance penalty group 1 or 1B less than 1 gram. I don't have any information about a misdemeanor offense in this writ.
Harboring a runaway is harboring one is a Class A, and the bond's $50,000.
Okay, that's the Class A.
Yes, sir.
And you said he's been in jail how long?
September 3rd.
And Your Honor, that is, Mr. Lowe is correct. That is a Class A misdemeanor. However, under 17-151, he's only entitled to a PR bond if that is the only charge holding him. Clearly here, it is not the only charge holding him.
Want to respond to that, Mr. Lowe?
She's correct, Your Honor. I think that the poor quality of these cases, though, if you have a chance to look at the exhibits that I filed, and I'll offer them at appropriate time, it's absolutely ridiculous about a bond. It's ridiculous.
Your Honor, and we object to the court considering any, quote, exhibits that were filed that were attached to a motion by Mr. Lowe, as they have not been authenticated as true and correct copies.
Now respond, Your Honor.
And Mr. Lowe, why don't you go ahead and offer whatever it is that you want to offer so I can consider it, rather than just referring to them. Tell me what it is you're offering and on what grounds this Curry can object, and so I can.
Yes, Your Honor. So I had filed, and I gave copies to Patty, not Patty, the other lady, copies of the documents that are attached as Exhibit A and B, and I'll call myself to authenticate those, Your Honor.
Unless he's a records custodian of whatever police agency he's going to assert they are from, I don't believe that authenticates them, Your Honor.
Go ahead and lay some foundation for exhibits A and B so that we can refer to them on the record as to what they are and to whom they are from, so that we can move along in this here.
Okay. So Exhibit A is called, it has title overdose.
Okay.
Exhibit B is called runaway.
Okay.
All right, and Your Honor, I didn't take the oath.
Well, I'm not sure I'm comfortable with you authenticating these. I'm not sure that you have personal knowledge regarding whether what's contained in these records are just contemporaneously kept, if it's kept in the normal course of business. If I allow an attorney to authenticate what they're giving the court, then I'm not sure that we would need the rules of evidence anymore. So So just go ahead and tell me what is Exhibit A and tell me what is Exhibit B and offer them so that Ms. Curry can object so that I can tell me what they are, where you got them, what they purport to be, the relevance, so that she can make her objections. If
I'll make a proffer of proof then, Your Honor. My name is Doug Lowe. I'm an attorney licensed to practice law in the state of Texas. I've been licensed since 1979. Prior to, I was elected district attorney for Anderson County for 16 years. Before that, I was a board certified personal lawyer. I'm licensed by the United States Supreme Court, the Fifth Circuit, the Eastern District of Texas, and also licensed by the Territory of Americans. And with respect to Exhibits A and B, Your Honor, I made an open record to the city of Wills Point, paid my $6 to the city of Wills Point, went to their office, and their secretary and I, her assistant, not sure what her name is, provided me with copies of the offense reports. These actually, although there are two exhibits, there are actually 4 different charges. So, Your Honor, since that time, these are just the narratives. There are other different pages, but these are the narrative portions of those reports. And I'll offer these as an exception to the hearsay rule set out in the Rules of Evidence 1013, in that for bond hearings, the Rules of Evidence hearsay rule don't apply. So that's my testimony as far as authenticating or in offering these exhibits. That's our proffer of proof.
Thank you, Mr. Love. Ms. Curry, any objection?
Yes, Your Honor. State objects. I am not making a hearsay objection. I understand hearsay, but hearsay is different from authentication. And we object in that they have not been authenticated in any manner. There is nothing that indicates that they apply to the offense for which this man is charged today, the offenses for which he is charged today. There is nothing that indicates that they are final reports. There's nothing that indicates they are, in fact, legitimate reports made at or near the time by someone with knowledge in the Wills Point Police Department.
Thank you, Ms. Curry. Any response, Mr. Love?
So, Your Honor, the reason that we reset this today, if the court will call, is I offered the state to have time to review these documents and get whatever they needed to be able to see if they were what they were, to evaluate the case and to look at these documents. And apparently today is the first day they actually looked at what I had. So I think the state's being disingenuous in their objection. Also, the rule, as I recall, says that the rules don't apply in a bond hearing.
And Judge, I'm sorry, I thought he was finished.
Not just the hearsay rules, but the portions of the rules. So we're offering these under a proffer of proof as evidence that authenticated by virtue of I was the one that went and got the documents. The city Wills Point gave them to me under a lawful open records request.
Thank you, Mr. Love. Ms. Curry.
Today is absolutely not the first day that we have seen these documents. I personally saw them last week, the day he filed this. The reason this hearing, my recollection is the reason this hearing was put off was because he had just filed them that morning last week, and Mr. Hartwell, who was physically in court that day, although I was on Zoom, Mr. Hartwell, who was physically in court, had not had a chance to see them because he had gone straight to the courthouse and had not, in fact, seen the email from the e-file system that contained these documents attached. So yes, I did see them myself, whatever the last day was, sometime last week or the week before, the actual day that they were filed. However, this is a bond hearing, not a probable cause hearing. Mr. Lowe has both orally and in writing told us that he is not challenging probable cause. This is a bond hearing. It is his motion and his burden to have a witness here to support the document that he is attempting to offer into evidence, and we continue to object.
Ms. Curry, do you want to respond to Mr. Lowe's assertion that the rules of evidence do not apply to hearings regarding bail reduction, issues of bail?
I think the rules of evidence, I think that's correct, Judge. The rules of evidence themselves do not apply, but there still has to be some authentication, some proof that it is what it purports to be. And we have nothing. This could be a first draft preliminary report that a final is not done yet. There's nothing even on this report to say it purports to the offense. It pertains to the offense for which he is in jail right now, the offense for which Mr. Lowe is seeking a bond reduction.
Mr. Lowe, is there anything in Exhibit A and B that is directly relevant to your client?
Yes, Your Honor. He's mentioned in both reports, and they go to his location at the time the drugs were seized for the state jail cases, and his involvement in the misdemeanor, and also his involvement in the delivering of controlled substance to a minor. So he's in all those reports. He's mentioned his.
All right. The court will overrule the state's objections to the admissibility, the authentication of Exhibits A and B. The court will admit Exhibits A and B for purposes of this writ and the consideration of bond. Go ahead, Mr. Lowe.
Thank you. So I need to call my client on the issue whether or not what bond he can make.
All right. Mr. Lyons, you'll raise your right hand. I'm going to place you under oath. Mr. Lyons, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Go ahead, make sure we speak. You can lower your hand. Go ahead and make sure we speak one at a time. Go ahead, Mr. Lowe.
Yes, Your Honor. State your name, please.
Jonathan Lyons.
And are you presently incarcerated in the Van Zandt County Jail?
Yes, sir.
And you have 4 bonds, is that correct?
Yes, sir.
A bond of $100,000 for delivery of controlled substance or marijuana to a child.
Yes, sir.
A bond of $50,000 for harboring a runaway child, misdemeanor Class A. Correct?
Right.
Possession of a controlled substance, penalty group 2, less than 1 gram, state jail felony, bond of $10,000.
Yes,
Correct?
sir.
And then finally, a possession of controlled substance, penalty group 1, less than 1 gram, state jail felony, bond $10,000.
For sure.
All right. Are you able to make those bonds?
No, sir.
All right. Tell me where you were living prior to your arrest.
In the garage of the home that they came to.
And do you pay rent?
Yes, I pay just for the garage part. I don't live in the front area of the house. And where we live at is in the garage.
Let me stop you. Just try to answer the question. You live in the garage?
Yes, sir.
All right. How much rent do you pay?
Like $2 something just for the garage.
All right. And do you have a regular job?
No, sir.
What do you do for money?
I mow yards.
All right. And who lives there with you?
My wife,
And what's her name?
Devin Dunlaps.
Does she have a job?
No, sir.
All right. Do you own any real estate anywhere?
No, sir.
All right. As far as personal property, do you own a car?
No, sir.
Do you own a truck?
No, sir.
Any vehicles of any kind?
No, sir.
What property do you own?
I don't have any property.
Well, do you have a lawnmower that you use?
Yeah, I have a lawnmower.
Any other tools that you have?
Just stuff to do lawnmower equipment to do yards. I got a weed eater, a lawnmower, and stuff like that.
Do you have a bank account?
No, sir.
Do you have any stocks or bonds?
No, sir.
Do you how much cash? If I turned you over and shook you out, how much cash would you have in your pockets before you were jailed?
Zero then.
Okay. All right. So the bonds now, I think a total of $170,000. You can't make that. We've talked about that there is a bond that you think you could make
10,000.
for all these cases?
Right.
Or however the judge would want to divide that up. You could make a $10,000 bond?
No, sir.
No, I just said you could.
I probably could, but I mean, I have to sell my lawnmower equipment and what I have to work with.
Okay, well,
I mean, I've just got to be honest.
okay, well, so are you able to make, if you sold your equipment, are you able to make a $10,000 bond?
Probably so.
All
Yes,
right.
sir.
All right. And if the court set a bond and gave you bond conditions, would you be agreeable to stay in the county? Van Zandt County.
No, sir.
You can't stay in Van Zandt County?
Yeah, I stay in Benson County. Yeah.
You're not going to leave.
Oh,
Right. Are you willing to report to the probation department?
yes, sir.
Mr. Carl, bond supervision officer, you're willing to report to him?
Yes, sir.
And you're willing to have any conditions of like wearing a monitor or ankle bracelet
Yes,
or
sir.
curfew? You're willing to have all those bond
Yes, sir.
conditions? And are you willing to provide the court or the probation department your analysis assessment
Yes, sir.
or anything that they want?
Yes, sir. Anything they want.
All right. That was for limited purposes of his financial ability to make a bond, and we'll pass away to Your Honor.
Thank you, Mr. Lowe. Ms. Curry, any questions for Mr. Lyons?
Yes, Your Honor. Thank you, Judge. Mr. Lyons, how many bondsmen have you talked to so far?
No, none, ma'am, because I knew I couldn't make them.
So you haven't tried to talk to a bondsman at all? You haven't tried to make a bond at all?
No, sir. I couldn't make 170,000. I can't make that.
How much money would that take?
A lot. Well, like what? $15,000? At least that.
And has a bondsperson told you what it would take?
I haven't talked to one, ma'am, because I knew I couldn't make it. So I'd be like,
Has anyone in your family talked to a bondsman?
I don't know that because I only talked to my wife one time, and she was telling me about the medications they found in a pill bottle that was already in the garage before we moved in there, and that was all it said.
Just answer her question.
What was the question again? I'm sorry. I'm just mad because I feel like I'm in here for no reason. I'm sorry. But
When's the last time? I'm sorry, sir. Go ahead.
What was your question, ma'am? I'm sorry.
Before you came to jail, when was the last time you mowed a lawn for money?
Just a couple of days before then.
Okay. What kind of lawnmower do you have?
A self-pedal push mower.
How do you get to these places where you mow lawns?
I walk to them. I push my lawnmower with my weed on top of it, and I push them around the neighborhood. Everybody know me around the neighborhood, so I got some good yards up. But it took me all.
When's the last time? I'm sorry.
Go ahead.
When's the last time you smoked methamphetamine before you came to jail?
A long time. That's why I don't understand why would they say that. I haven't been in trouble in 4 or 5 years. I ain't been on meth in so long. I found my wife. When I got my wife, that's how long I haven't been on meth. I've been with her for 4 years.
But there was meth in your house, or in your
It wasn't no
garage.
meth. They said it was pills. There wasn't no meth in my house. It was some old pills that they found inside a pill bottle. It was Vicodin.
That's one of the
Wasn't no meth.
charges. That's one of the charges. So you're saying there wasn't any ice in your garage?
It shouldn't have been unless it was already in there. Ma'am, I live in a garage that somebody let me live in. They
Right.
still had stuff that belongs to other people was in that garage. That's why I didn't know about none of that. My wife lived there too. So if they found all that, why they didn't arrest her?
Well, but they did find a young man OD'd on the front lawn, right?
That's had to do with the front part of the house. I live in the garage. I live in the back. I do not know what's going on in the front. So
Were you aware that young man told the police that he got it from you?
I was aware of that after the fact, but I have never ever sold drugs since I've been with my old lady. I go and mow yards, and that's what I do, try to take care of my old lady the best I can. I never sold drugs to that kid. I got 4 kids myself. My youngest
Okay.
is 17. I would never hurt nobody's kids.
And Let's talk about your criminal history. How many times have you been to TDC, Mr. Lyons?
One time. I've been to state
How many?
jail once.
You've been to state jail how many?
Once.
Okay, so you've been to state jail?
I've been to prison once, back in 2013 for possession. That's when I had a drug problem. I beat that drug problem 4 years ago.
And you've also been to state jail once?
Yeah, a long time ago, about the same time. Ran at the same time because I got put on. I went to prison. Then I got out. I was on parole. And I caught another case while I was on parole, drug charge on patrol, and then I went back to doing 6 months, and I haven't been back in trouble since. That's when I met my old lady. I've been with my old lady ever since. I put that on everything I love. I mean, I can kiss the ground if I'm lying to you.
Well, your criminal history doesn't exactly say that they ran at the same time, does it?
Well, it was all around about the same time. I know I went to prison for possession. I got out with 6 months left. I don't know if I completed it or not, but I got back on drugs. Then I went to prison, state jail. Then I got out. Then I've been good ever since. I ain't been in no trouble ever since. And I damn sure ain't never sold no drugs to no kid.
So you went to prison. You went to prison once out of Kaufman County, right?
That's the one I went with the possession. That's the one. Then I got caught in Rockwall with less than a gram. There was 4 people in the car, actually, and they all ganged up on me and put the charge on me, so I went ahead and took it. So I did 6 months state jail for that.
So you pled guilty to some. So you pled guilty to something you weren't guilty of.
Yes, ma'am. Basically, I did.
So you committed aggravated perjury.
So I guess I was just as guilty as they was. So let me rephrase that.
And in addition to that, you've been convicted of about 14, if I counted them correctly, misdemeanors,
Yes,
all
ma'am.
at different times.
Yeah, I've been convicted of misdemeanors. I have. But
All at different times. That's not counting ones that ran at the same time or anything like that.
I don't remember all of them, but I know I have been here quite a few for some misdemeanors. Yes, I have. I know me and my boss got into it one time. It was a terrorist threat, class B. And me and my girlfriend got into it a long time ago in, I think 2017. And just, and that was it. I came back on the same one because I missed court with Joshua Winters, with Mr. Winters, whatever his name. I missed court.
So about how many times have you missed court?
Just that one time, because I got out the next day. I supposed to be reporting. I didn't find a ride in time. So, but I called him and let him know. I called the courtroom and let him know.
And the only time that you have ever successfully completed a probation was way back in 2004 that ended in 2006. Is that right?
That was the time I went to prison. Yeah, because I had a real bad drug problem then.
But you actually successfully finished that probation that you were put on in 2004.
Yes, ma'am.
Is that right?
Yes, ma'am. I think
And that's
so.
the only time you have ever, out of 14 misdemeanors and 2 felonies, that's the only time you have ever successfully completed a probation. Is that correct?
If that's what's on the paperwork, yes, ma'am.
Okay. So all those times, 14 separate misdemeanors that were all at different times and 2 felonies, so 16 total separate cases that you've been under court supervision for, and since 2004, you've never successfully abided by the conditions,
I
correct?
always did time. I got time served. I really did my time in jail and got time served for most of all of them. That was it.
Well,
I got
both of those felonies started out with a probation, correct?
one of them did, and the one in state jail, I went from state jail straight to I signed in Rockwall. The state jail, I went straight to state jail. I never was on probation for that. Only was on probation for that one. That's the one I completed. The rest of them was misdemeanors that I went ahead and just stayed and done the time on.
Fair
Yeah,
to say there's been more than a dozen times that you've been put on supervision by a court that you failed it.
I really don't remember all that. I remember, on misdemeanors and I just go ahead and do my time. Or I was like, I don't have the money or something. I rather go in jail and sit it out or go back to jail because I ain't got money to afford to pay. You know what I mean? But if I'm on something, I'm going to try my best to complete it. Like I did the first time. If I got my mindset on it, I'm going to complete it. If I mess up, I take that.
Because that's what you did back in 2004. You completed it.
Yes, ma'am. I can complete anything. I promise.
I'll pass the
Give me a
witness,
chance.
Judge.
I would do it.
Mr. Lowe, your witness.
No more questions for the witness, Your Honor. Thank you.
All right, Mr. Lowe, any additional witnesses or evidence?
No, Your Honor.
State any additional witnesses or evidence?
No, Your Honor.
Mr. Lowe, would you like argument?
Yes, sir, Your Honor. And if the court will indulge me just for a few minutes to talk about these different offenses. So let me speak on a runaway, which is a Class A misdemeanor. And it requires that a person commits an offense if he knowingly harbors a child, and he is criminally negligent about whether the child is younger than 18 years, and the relevant part is voluntarily absent from the child's home without the consent of the child's parent or guardian for a substantial length of time, or without their intent to return. So the facts are that Paul comes into Will's Point about 6:43.
Your Honor, we're going to object to any recitation of facts by Mr. Lowe.
Are you arguing off of exhibits A and B, Mr. Lowe?
Your Honor. Yes, Your Honor.
You are. Which one are you referring to?
This is Exhibit B, and I apologize. Exhibit B, Your Honor.
Okay.
So,
The court's going to overrule the objection.
according to Exhibit B, the call comes in at 6:43 p.m. and the mother of the child says that the child has been missing since this morning, but it was a school day, and the child told her that she was being bullied at school. And the juvenile told the mama that she had legal documentation that said she had the right to do what she pleases. So the mother on that call at 6:43 tells law enforcement where she thinks her daughter is. Then at 12:54 a.m., which is just the next morning, the law enforcement goes to road 2140. And then shortly after that, they go to the address where there are two other people that live there, Mr. Covey and
His brother was living there at the time.
Hang on.
It's like,
Hang on, Mr. Lowe, hang on. I can't. We're in argument here. So unless he has a law license and representing himself, I don't need to hear from him.
right, yeah, you just let me. I was just collecting my thoughts.
I'm sorry.
So anyway, turns out when the police go to investigate the case, that they determined that there was a person named Derek Silva that brought this girl over to the house, not to the garage, but to the house where Mr. Lyons lives. And the juvenile was not found in his part of the house, but in a bedroom of the house. And Mr. Silva jumps out of the window before the officers arrive. So the report indicates that Ms. Curry advised the police department just to arrest anybody that was there. So he was caught up in this. So first of all, with regard to that one, if the court does not grant a PR bond, we need a reasonable bond, which there is not evidence that there was from the child that she did not intend to return home, that she was gone for a substantial length of time, because they're only talking about 6 hours from the time the mother called the police, and that there's no evidence that Mr. Lyons harbored the child. And that's our argument on that one, Your Honor.
All right. Any argument as to reasonable bail on the other 3 charges?
Yes, Your Honor. So according to the report that I filed Exhibit A, I'm referring to, the way that case starts out is the mother of a juvenile who I think is about 17 years old. She finds him in her front yard, not his front yard, the mama's front yard. He's been gone for 48 hours away from home, and there's been no reports the child has been missing. But she finds him, calls the law enforcement. They come out and get a statement from the juvenile that he was smoking, and I don't think the word is meth, it's just drugs, smoking drugs with Mr. Lyons and Mr. Covey. So the thing that's in the report about the juvenile, apparently this juvenile has been kicked out of Wills Point School for selling drugs. And I'm
nowhere in that report. That's a total surmise by Mr. Lowe.
I apologize. It's been a long day, Your Honor. So anyway, so the law enforcement that gets a search warrant to search the premises where Mr. Lyons lives. And they go to do the search. Mr. Lyons is not there. He's somewhere else. They locate him somewhere else. But during the search, they find 0.91 grams of methamphetamine laying on a cell phone. Well, that's not where the juvenile said the drugs were. The juvenile said the drugs were in a drawer. So we're talking about 0.91 grams of methamphetamine where Mr. Lyons is not there. There's somebody else there, but he's not there. Also, with regard to the penalty group 2 offense, it's 1 Vicodin tablet. 1 Vicodin tablet in a I think it's in a pill bottle with somebody else's name. So I think that's a shorthand version of the facts, Your Honor. So I think that the bonds are totally ridiculous for 1 Vicodin tablet, 0.91 grams of methamphetamine, a case where a minor says after he's been missing 48 hours that he's been smoking methamphetamine with Mr. Lyons and another person. So we would urge the court to make reasonable bonds that would total not more than about $10,000 that Mr. Lyons says he can make. And that's our argument, Your Honor.
Thank you, Mr. Lowe. Ms. Gray.
Your Honor, I would simply point out that the speculation of Mr. Lowe that it was 1 pill is 100% not correct. That is not supported by that report. He's put a lot of evidence in front of this court today that is all based on what we don't even know whether that is a final report or not. The bonds in this case, Judge, are not unreasonable. $10,000 for a repeat offender on a state jail felony is not an unreasonable bond. $100,000 for supplying methamphetamine to a juvenile, even if he is 17, which again, there's no evidence of, is not an unreasonable bond. $50,000 for a Class A misdemeanor. If the court wants to adjust that bond to something more in line with what is traditionally done in this county, the state would have no objection to that, Your Honor. But $10,000 for state jail felonies, $100,000 for giving for a probable cause finding by a magistrate that this man was distributing methamphetamine, delivering methamphetamine to a minor is not an unreasonable bond, Judge.
Thank you, Ms. Gray. Mr. Lowe, last word.
So, Your Honor, the report indicates that there was one M366 hydrocodone and acetaminophen, pill. So, according to the report now, and so, Your Honor, the police, the district attorney's office is obviously able to get additional information if they wanted to complain about what's in these reports and the accuracy of it. And so, with that said, Your Honor, it's their business, however they want to do it. Bonds are just outrageous, need to be reduced.
All right, thank you, Mr. Lowe. All right, the court's going to take this, take arguments and evidence under advisement. The court's going to review exhibits A and B. We'll consider those in correlation with the arguments and testimony today, and the court will issue a ruling on the writ at the close of business today.
Thank you, Your Honor. That's all we have.
Thank you, Mr. Lowe. Thank you, Ms. Curry. I will, whatever decision I make, I'll make sure that Ms. Abraham sends a copy to both the state and to the defense.
Thank you, Your Honor.
All right, thank you, Mr. Lowe. Thank you, Ms. Curry.
You bet.
All right, I believe that does conclude the court's afternoon criminal docket, correct?
Jonathan Lyons sat before a Texas judge, shackled by 4 charges and $170,000 in bond he couldn't touch. His attorney, Doug Lowe, a former district attorney with decades of experience, walked into court armed with police reports obtained through an open records request, ready to fight for his client's freedom. The charges were staggering: delivering a controlled substance to a minor, harboring a runaway child, and 2 separate drug possession felonies. The defense argued the bonds were absolutely ridiculous. Lowe painted a picture of a man wrongly swept up, a garage tenant who mowed lawns for a living, whose landlord's house became a crime scene without his knowledge. He pointed out that the meth found weighed less than a gram, that a single pill in a bottle bore someone else's name, and that a teenage boy's statement was the only real evidence tying Lyons to drug distribution. Then the prosecutor, Miss Curry, stood up. What followed was a masterclass in controlled destruction. She methodically walked Lyons through his own history: 14 misdemeanors across different years, 2 felonies, and a probation record so poor that he had only successfully completed supervision 1 time since 2004. Lyons tried to explain himself, growing visibly emotional on the stand. "I'm just mad because I feel like I'm in here for no reason," he told the court, a moment that hung heavy in the air. He admitted he'd pled guilty to charges he claimed he wasn't responsible for. He admitted he'd done time rather than meet probation conditions repeatedly. He insisted he'd changed, that finding his wife 4 years ago turned his life around completely. The judge took everything under advisement, promising a ruling by close of business. Was justice served? Was $170,000 truly reasonable, or a punishment before a verdict? What do you think? Should the bond have been reduced? Drop your verdict in the comments. Backhand index pointing down.